Good afternoon. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County. I'm going to call the calendar for the motions calendar for May 7th, 2025, the 1 p.m. calendar. All right, first on the calendar is Angela Lewis versus Luis Vasquez and several Johnson defendants and corporate defendants.
Good morning, Your Honor. Nina Hassan here for the plaintiff.
Yes, Your Honor. Jimmy Cannell, I'm here on behalf of the defendant.
And Judge, I'm the court reporter here for that case.
Right, thank you. All right, on the next case on the calendar is Ollie McMillan versus Horace McLean, Everett Fuller, and First Acceptance Insurance, which I believe First Acceptance was dismissed. So McMillan versus McLean and Fuller.
Good afternoon, Your Honor. Mary Page Gray for the plaintiff, who is also here. I don't see the defendants. This is a hearing on damages in a default judgment case.
All righty. Next is Arnold Weisinger versus Anaya Norris and Hartford Insurance Company.
Good afternoon, Your Honor. Michael Wetzel for Hartford, and I have good news for you. All the motions have been withdrawn.
Okay. All right. Well, y'all are free to go at this time. I love consents.
Actually, Judge, there was one more thing that I wanted to ask about. We had a motion for publication that we filed a while back, and if you could get us in order today, I would be so happy.
Would. All right, Miss. Did you submit a proposed order?
We did.
Okay, Miss Powell, do we have that proposed order?
Let me look for that right now. System is loading it. Okay. I see. Do you know what date it was filed, sir?
Back
approximately
in November, I believe. Here, I'll look it up. Let's
see, 12/26.
11/21/24, I think, maybe. Hold on. Let me see if I have a date on that.
There are several different things that were filed on 11/21/24, but they weren't marked separately as motions that we needed to review. So that's why they were missed. I'm sorry about that.
No, I'm sorry.
Get that out.
Yeah, Ms. Powell.
There are like 4 different. I see the motion for service by publication, and then I can go through the other 3 really quickly to make sure.
And there is a proposed order on it.
Okay, great. If you see it, then it's there. I won't hold the court's time. but I'll get that over to you, Judge.
All right, thank you. No problem. All right, so anyone here on Weisinger versus Norris, you're free to go at this time. We'll get an order out.
Thank you, Judge.
Thank you, Your Honor.
Gibbs versus Remy Holmes. This is a review of a dispossessory.
Yes, good afternoon, Your Honor. Hans Dara for the respondent, Resi Home.
Okay, it says Remy Holmes on here.
Yeah, we didn't draft it, so.
No problem. All right, is there any representative from the Gibbs here? Plaintiff, the petitioner's Gibbs. All right, Gibbs, in the courtroom? Nobody's in the courtroom. So at this
Your Honor,
time,
happy to give a little bit of a procedural on this one. This is a petition for review that was filed probably a month late. It was a consent order anyway in magistrate court. I think they filed an emergency motion in the magistrate court that never got took up. They've already been set out. So it's just our position to dismiss the petition based on the fact that it was a consent order and it was also filed too late. And just reinstate the consent order and writ and just dismiss their petition.
all right. Were there any costs also?
We pled just for possession at the time, so we're not seeking costs today. I'll include the fact that they weren't here as well in the proposed order.
Okay, send me that and we'll be good.
Yes, Your Honor. Thank you.
Thank you. And California Casualty versus Marlene Corcoran and Antonio Barnes. California Casualty versus Marlene Corcoran and Barnes, Antonio Barnes. Have you heard anything from them, Ms. Powell?
One second, Judge. I do not have any memory, but let me check my email and let me just check the record.
All right, so having nothing from either side, we'll dismiss the motion for the post-judgment proceedings. Next is Samuel Fields versus Willie Pittman and Reindeer Remodeling LLC.
Samuel Fields is here for the plaintiff.
Anyone here on behalf of Willie Pittman or Reindeer Remodeling?
Yes, I'm here.
Okay, who responded?
Willie Pittman.
Oh, Mr. Pittman, you're in the library. Okay, there you go, sir. I just needed to have you bring that down a little bit.
Sorry, Your Honor, I don't know anything about these computers.
That's okay, Mr. Pittman. All right. All right, so last case on the calendar is In-Town Suites Management versus Maryland Goulburn.
John Richard for In-Town Suites, Your Honor.
Yes, ma'am. This is Marilyn Goulburn, Your Honor.
Okay.
And Brianna Lowe.
From In-Town Suites.
Oh, okay, under the all others.
From In-Town Suites.
From In-Town Suites, Your Honor.
Oh, I'm sorry. Okay. And that's
just to
sure.
update you.
Yes.
Oh, I'm sorry. Oh, wait.
Go ahead.
So there was no additional filings into the case, no email. Again, the mail was returned from Marlene Corcoran, who was the one that filed the motion. So I'll do research for this.
Okay, but Ms. Corcoran's here, so she's submitting herself to the jurisdiction of the court. She got notice somehow.
Yes.
Oh, okay. You were just wondering if we had heard anything from plaintiff.
For the California Casualty.
Yes. Okay. So no, we have not heard anything from plaintiff. No.
Oh, I'm sorry. Corporate. We're talking about corporate instead of Goulburn. Okay. All right, in that case, that will be dismissed for want of prosecution of the motion. All right, so let's go to Lewis versus Vasquez. All right, Mr. Vasquez, Mr. Canella and Ms. Hassan.
Yes, Your Honor. Here on defendant's motion to enforce the settlement.
Okay.
And may it please the court, Your Honor, my name is Jimmy Cannella. I represent the defendant. We're here on the motion to enforce settlement demand. This case stems from a motor vehicle accident that occurred December 7th, 2022. The plaintiff alleged injuries, hired Morgan & Morgan to represent her. They sent the demand over on March 20th, 2023. And I then sent an acceptance to that demand on April 10th, 2023, which is marked as Exhibit B, and I have it up on the screen, Your Honor. Also, Exhibit B to defendant's motion to enforce the settlement. It was to Evan Rosenberg and just said, hey, received this demand. They would like to accept. I have attached the affidavit that there is no other coverage. Also request the check should be there soon. So I accepted and also provided them with the affidavit of no other coverage. Then sent over the check April 18th within 10 days, 2023. Then about 1 to 2 months after I send over the check, I normally start to give plaintiff's counsel a call or email and just to check on the release, which I did in this situation. And I think I included one in here, which was an email in June 2023 that essentially says, yeah, it's Exhibit D, that essentially says, hey, could you send me the copy of the release? And so I usually follow up by phone, by email with plaintiff's counsel just to check on the signed release. This one I called also. They said, yep, everything's fine, no problems. We're settled, just waiting for a plaintiff to come in and sign the release. I said, that's fine, that's all right. So it just kept on kind of moving along. 6 months later, after sending the check, then that's when I get a letter of representation from a new attorney. And this is Exhibit E in my motion. And so I get a letter of rep from another attorney. And so I email both attorneys, the new attorney and the Morgan & Morgan attorney, saying, hey, I just got this letter of rep. We accepted this. Where's the release? And Morgan & Morgan then emailed me October 6, 2023, saying, we don't represent her, client decision. So essentially the plaintiff fired Morgan & Morgan for whatever reason, but fired them after we had sent them the check and everything. And then she just fired them at that point in time. Called them that day and said, what is going on? You told me it was settled. There's no issue. And he said, oh yeah, it was settled. But when she realized there was only a certain amount of money, she wanted more money. And so she fired us. And so then another demand came, the lawsuit came, and I essentially went back to Morgan & Morgan and I said, you told me during this time that the case was settled. And then you told me, hey, yeah, you got a letter of rep that she fired us because it was settled, but she wanted more money. So I said, okay, well then put that in writing, what our discussions were during the settlement. And that's when they sent me the email, which is Exhibit F, and says, hey, James, yep, 25 was all there was. We settled at that. Angela didn't accept that there was all there was to go for. And then that was the reason for firing. So I wanted him to reiterate what we had discussed over the phone during the settlement, that the settlement was good, but that she wanted more money. And that was the reason she fired them, the client decision that she fired them at that time. After suits filed, then I go ahead and file the motion to enforce settlement. And actually at that time, plaintiff's counsel, I mentioned to them that, hey, you understand that this was settled already with Morgan & Morgan. They did not know that. So I had emailed them all the documents showing them settling, didn't hear from them. So that's when I filed the motion to enforce the settlement. The motion and the motion basically is filed saying that the settlement there. Then we get a response from plaintiff's counsel, and the response really doesn't have a reason why, but the brief does contain a reason saying that the affidavit wasn't worded the way they thought it should be worded, is essentially they're saying why they're saying that this should be rejected. They have they raise no issues with the demand itself, with the acceptance of the demand, with the delays when the check is received, when the affidavit's received. They have no issues and don't raise any issues with regard to the apparent authority of Morgan & Morgan to settle on behalf of the plaintiff. So there's no other issues with this demand or the settlement, other than they say that the affidavit saying that is there any other coverage should be worded differently, is essentially what their argument is. The law in this issue is pretty straightforward from my research, and I think both plaintiff and defense counsel have similar law cases in their briefs that regurgitate kind of the same law that is out there, essentially that there must be a meeting of the minds. That's the Bildball case. That an offer must be accepted unequivocally without any conditions, the Torres case, and that the law favors compromise when there is an agreement to settle. That's the Bildball case again. Again, there are no issues, so I'm not going to go into more detail with regard to the settlement other than the affidavit that is brought up by plaintiff's counsel. The demand itself is attached as Exhibit A to my brief, and if you go to page 4 of Exhibit A, on page 4 it has one of the terms is number 7, and it says, pursuant to the statute, in order to settle this claim, State Farm must provide Angela Lewis a statement under oath regarding whether all liability and casualty insurance issued by State Farm once, and I think the once is out of place there, but State Farm that provides coverage or may provide coverage for the claim issued has been disclosed to Angela Lewis. And so that's the paragraph that is in question. Then so essentially they're saying, give us an affidavit, let us know whether all liability and insurance coverage has been disclosed to us. And so the affidavit that is provided is Exhibit B, under Exhibit B. And it says from Lynette Hudson with State Farm, and paragraph 2 says, on the date of the accident, the only insurance policy applicable to the defendant and the vehicle he was driving and to the plaintiff was policy number such and such, and then limits $25,000. Paragraph 3, I do not know of any other policy of insurance at the time of this accident that could provide coverage for any injuries to Angela Lewis. So the purpose of, as your Honor knows, the purpose of this requirement of the affidavit in the statute is to disclose all insurance, make sure that all insurance is provided to the plaintiff's attorney so they know what they can go after, make sure what insurance is out there. And with this affidavit, that is exactly what has been provided. We provide them, this is the policy that is in question, this is the policy that applies, and there is no other insurance policy that pertains to this accident or this case or the plaintiff. And so the purpose is to find out insurance, and then so we tell them exactly what insurance is applicable and that there's no other insurance out there. The demand itself, again, doesn't specify or say that we have to use any specific wording with regard to our affidavit. It doesn't say that we have to set forth any terms, specific terms in the affidavit. All it says is that we need to say whether all liability insurance has been disclosed to the plaintiff. Simply enough, just tell us what insurance is out there and what insurance applies. And so there are no strict rules or specifications or guidelines that are provided in the demand other than just let us know what other insurance applies to this case. And Your Honor, that's what we provided with the affidavit. We told them what policy it was, and we said that there's none other that applies other than that policy itself. And further, that's why the email is important to memorialize our conversations during the settlement with Morgan & Morgan, that they told me a number of times over the phone, the settlement's good, we're fine, just waiting for the plaintiff to come in. That, you know, and then when we do get the letter of rep, yep, the settlement was fine. She just was not happy with the money. And that's exactly what we discussed during the time of this settlement with Morgan & Morgan.
All right.
I'm sorry.
No problem. Ms. Hassan,
Oh, I'm sorry, Your Honor. I had just a little bit more.
go ahead.
Just 2 more minutes, Your Honor. I'm sorry. And the cases that are cited in both briefs, really, there's really no cases that touch on an affidavit in particular. They go into other things, and then even the cases by the plaintiff, the Grange case, which is basically all deal with a condition, a new condition by the defendant, which basically means the settlement is no good. Like the Grange case where the check was late, the Torres case where the defendant asked the plaintiff to satisfy all liens in the acceptance letter, and then the Cone case where they had a disagreement orally whether it should be a general release or a limited liability release, and there was nothing in writing, so the court couldn't do anything with that. And then the Ligon case, finally, where we actually cited that one also, where the plaintiff's attorney accepted, the plaintiff wanted to continue negotiations, and the court said, no, your attorney accepted, everything is concluded. One last thing, Your Honor, and I'll end here, is that we did, when I can't find any cases on an issue, I normally go to secondary sources because, and try and look up secondary sources to see if there's anything else, because there was really no cases, particularly on the issue of the affidavit. And that kind of tells me also that it's nothing there's nothing out there. You just need to answer the question of, was there any other insurance available? However, when I was looking at Jenkins and Miller and these other ones, Davis and Schulman, Browns, I did find actually one of them on Westlaw, and you could see it up at the top, this is from Westlaw, this is from Browns, and it's written by Charles Adams and Cynthia Adams, Browns forms, and they actually had a form for 91167.1, the statement regarding insurance. And it says, number 1, my name is insured, the adjuster for the company. Number 2, all liability and casualty coverage that provides for this claim issues is as follows: policy number, amount, and that's just what we provided. Then 3, they actually just say this is based upon the settlement offer and everything's correct in this affidavit, whereas we go into even more, where we say there is no other insurance policy that applies to this accident. For those reasons, Your Honor, we would ask that the motion to enforce settlement be granted. Thank you.
Ms. Hassan?
Yes. Good afternoon, Your Honor. May it please the court, I'm here on behalf of plaintiff Angela Lewis. We're here in opposition to defendant's motion to enforce settlement. We believe we are here today on the issue of whether a settlement contract form. It's plaintiff's position that it has not. It's basic contract principle that a contract requires an offer and acceptance of the offer. Additionally, acceptance of the offer, excuse me, must be unconditional, identical, unequivocal, and without variance of any sort, citing Grange v. Woodard. And if there's any variance of any sort from the offer, the attempted acceptance is a rejection.
Ms. Hassan, let's
Yes,
assume I know basic contract law.
Of course, Your Honor.
Where it deviates from offer and acceptance, because to me it looks like the people with apparent authority were negotiating with each other and they were talking to each other. The policy limits are $25,000. You made a request for a demand for policy limits. We gave you policy limits. We don't have any other policies. Okay, send us the check. Okay, now that the check is in the mail, the plaintiff decided she was entitled to more money. So now she's fired the attorneys and wants to bring a lawsuit for. So where is the failure in the offer and acceptance rubric.
Yes, Your Honor. So just to cut it short, essentially our issue is with the language of the affidavit. And I understand, as Mr. Canella explained, that the overarching idea and purpose of what the affidavit they provided was seemingly to comply with what both the demand and the statute put forward, such as to say this is the only applicable policy and stating there, but the also let me share my screen. As you can see here, Your Honor, in number 7 of this page, this is the Morgan & Morgan original demand. It states that pursuant to 91167.1, in order to settle this claim, State Farm must provide Angela Lewis a statement under oath regarding whether all liability and casualty insurance issued by State Farm that provides coverage or that may provide coverage for this claim has been disclosed to Angela Lewis. So as Mr. Canella also went through, the affidavit itself essentially did not answer the exact question that this demand and the statute itself was asking.
What did it leave out?
So the statute and the demand, it essentially is asking, tell us whether these have been disclosed. So the two answers that you can give essentially are, yes, they have been disclosed, or no, they have not been disclosed. So the way it's written is essentially previous disclosure. So essentially what the affidavits, and both affidavits in this case just said is, this is the applicable policy, and they stated the policy as it was, and that we do not know of other policies.
Okay, so hold on. So you're,
yes, ma'am.
You're saying that the entire agreement should be invalidated because they didn't say, yes, we disclosed the policies and ended there. So that if they said, instead of disclosing the policies and telling you which policies are available, and the fact that the policy that they discussed is all the policy that exists, instead of giving you all of that information, what they should have just said was, yeah, we disclosed it.
Not just that.
Ms. Hassan, I'm not going to invalidate a contract based on form over substance, because we're all lawyers and we all draft things differently. And as long as the drafted information complies with what is required to give notice, which is the bedrock of due process. So was she given notice of what policies were available, what those policy numbers were, who was the provider or an underwriter of those policies, and whether they would cover the claims that she was making? Was she given all of that information?
Yes, Your Honor, but we also feel that the way this affidavit was written, it kind of leaves loopholes for State Farm to later come, and if there are resident relative policies or umbrella policies that exist, to later on plaintiff would not have a remedy. If this case was settled under this affidavit, if those policies are later discovered, as the way it's written is, that apply to the defendant.
Okay, then you would have a remedy against the attorney or for malpractice or some other remedy, but they've provided an affidavit that said, we don't know of it. Instead of just saying, yeah, we disclosed this through whatever conversations we've had or whatever information that a lawyer to a lawyer was being communicated, instead of just saying, yeah, we disclosed it, they've set out what exists, and they've said, we don't know, we're State Farm, we should know if they exist, if there's anything else. We don't know of anything else that would cover this accident and these injuries.
Yes, that's understandable, Your Honor.
Did you review, and you don't have to tell me what you reviewed, but did you review the file from Morgan & Morgan before you decided to take this case?
Yes, so we reviewed what the client had provided to us, and I did reach out to Mr. Canella to get additional documents, such as the email communications between him and the attorneys at Morgan & Morgan regarding the exact acceptance language. And then from what he provided and what he also showed here today, I'm not privy to the phone conversations that they had. I don't have the information from that, but from what they provided in saying, yes, there was an agreement prior to her firing us and coming over to my firm. It's our position that at that point, they had not made any kind of essentially ratification or acknowledgement that there was a settlement. So at that point, since they were no longer her counsel, we essentially weren't acknowledging that this was them essentially saying that there was a settlement.
Okay. All right. Anything else?
Yes, Your Honor. So additionally, as I stated, there was a difference between, in our position, a non-conforming statement that we think State Farm provided in response to both demands and how they stated it. We believe a conforming demand should have stated specifically disclosure language. Yes, all policies have been disclosed to Miss Angela Lewis or her counsel, or they have not been disclosed, and here are additional policies. We believe it as it stands, it just leaves open gaps for future recovery that the plaintiff would not be able to have. And additionally, as the affidavit stands, it shows that State Farm unilaterally made the determination of what policies applied and did not give any indication of disclosure or even search for other potential policies, and that would allow plaintiff to investigate or ascertain whether those policies could apply. And moving forward, this would allow State Farm and even other insurance companies to unilaterally make the determination and not give any plaintiffs the remedy of doing their due diligence and seeing if those other policies would apply. I don't understand the purpose of avoiding the disclosure language, as both demands clearly state whether or not they have been disclosed, and additionally, so does the statute itself. So as a result of this, we are asking to have all evidence viewed in light most favorable to the non-movement, which is plaintiff. And even if this court finds that the demand or offer didn't comply with the statute, we believe that as the offer was presented, it did accept everything in the demand, which, let me additionally just share my screen one more time. Later in the second demand that my firm sent in, all right, in number 7, this is essentially the same term that Morgan and Morgan sent. We provided additional clarifying language that any other statement not exactly as prescribed by 9/11/67 B1G regarding whether all liability or casualty insurance by State Farm has been disclosed to the offeror is refusal to comply with the statute, which is a material term, and it'll be considered a rejection of this offer of compromise. And like stated, we believe that it was not an exact statement of what was required, which effectively we took as a rejection and counteroffer. So therefore, we believe that the evidence taken in light most favorable to the non-movement, which is plaintiff, the court should find that there was no contract. And additionally, even if the court finds that the demand or offers did not comply with the statute, the defendant cannot accept anything other than the exact offer as presented, and contract formation is not a punishment for non-compliance of the offer. So therefore, we ask the court to deny defendant's motion to enforce the settlement. Thank you, Your Honor.
You're welcome. Anything else?
No, Your Honor.
All right. The court will issue an order. Thank you.
Thank you, Your Honor.
All right, you may be excused. All right, next is McMillan versus McLean and Fuller. Just give me one moment. I'll be right back. All right, ladies and gentlemen, I apologize. Thank you. McMillan versus McLean and Fuller.
Yes, Your Honor. Okay, there you go. Making sure her Miss McMillan's camera
At
was
the
on.
light, turn right onto Oakland Drive Southwest.
Okay, who turned? All right, ready?
Yes, Your Honor. Again, I'm Mary Page Gray. I'm here on behalf of Miss McMillan, the plaintiff. We're here to prove the damages she sustained as the result of a rear-end motor vehicle collision on October 1st, 2022. She incurred medical expenses and endured pain and suffering. So she will testify today and we'll introduce some medical bills and we'll ask the court to award a judgment that fully compensates her for her injuries.
Okay.
Plaintiff calls Miss Aaliyah McMillan.
Yes.
All right, raise your right hand for me, ma'am. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. Now, let me just clarify, you are riding, not driving.
All right.
All right. All right, go ahead, Ms. Gray.
Thank you, Your Honor. Miss McMillan, will you please state your full name?
Yeah, McMillan.
And were you involved in a motor vehicle collision on October 1st, 2022?
Yes.
Can you briefly tell us how the crash happened?
I was making a right onto Covington Highway, and as I was coming down the road, two vehicles smashed into each other head on, and they slammed to the back of my vehicle, causing me to be pushed down the road.
Was your car damaged in that wreck?
Yes.
Your Honor, may I share my screen and show her a picture of the back of her vehicle? It'll be Plaintiff's Exhibit 1. Okay, thank you. All right, Miss McMillan, do you recognize this picture?
Yes.
Are you able to see it?
It's still loading, but
Okay, I'll wait for a second.
I don't have a document. I just see that you're sharing.
I know I'm trying to get it to reset. I apologize for the delay, Your Honor.
Okay, no problem. I just thought it was me.
Well, in the meantime, I can ask you some questions and then we can show exhibits at the end once they load. So you said that your car was damaged in the collision. Can you describe it for us?
Yes, the back of my hatch was pushed in, my bumper was taken off, and my muffler was attached but hanging, and I also had some cords that were busted out and tail light.
Okay, can you see that picture now?
Yes.
Okay. Is this a true and accurate picture of the damage to your vehicle after the collision?
Yes.
Okay. Who took that photo?
I did.
Did you ever get this damage repaired?
No.
Your Honor, plaintiff moves to enter exhibit number 1 into evidence as a true and accurate picture of the damage to her car.
Exhibit 1 will be admitted.
Thank you. Miss McMillan, why did you not get your car fixed?
I was unable to pay for it at the time.
Do you know how much the repair would cost?
When I got an estimate just based off of somebody that I knew that worked on cars, based off of him looking at it and what I was hanging from it, the estimate that I got was over $3,000.
Okay, but you don't have a formal estimate to provide to the judge today?
No, ma'am.
Okay. After the crash, did you immediately feel any pain or symptoms?
Yes.
Okay, can you describe what you felt and what parts of your body you felt pain?
I had immediate back pain, some headaches, that were causing some numbness down my right arm. But the disc that I ended up that was bulging in my back from after my appointments, it was like a nerve damage.
Okay. Had you ever been injured in those same areas prior to this collision?
No.
Did you seek medical treatment after the wreck?
Yes.
Okay, the wreck was on October 1st, 2022. Do you remember how soon after the wreck you sought medical treatment?
I want to say I went to urgent care first, and I believe it was the day of.
Okay. Did you ever seek treatment at Georgia Injury and Spine?
Yes.
Okay, I'm going to show you what's been marked as plaintiff's exhibit number 2. It's a medical bill. May I go ahead and do that, Your Honor? I'll just scroll through these. Thank you. Ms. McMillan, you able to see this?
Yes.
Okay. And is this a medical bill you received from Georgia Injury and Spine?
Yes.
Okay, I'm going to scroll through so you can see the whole thing. Is this a true and accurate depiction of the bill and the charges you received from Georgia Injury and Spine?
Yes, ma'am.
And down here at the bottom, what does the total say?
$4,407.70.
Have you paid that bill?
No, ma'am.
To your knowledge, has anybody paid anything on that bill?
No, ma'am.
Do you still owe that amount to Georgia Injury and Spine?
Yes, ma'am.
What kind of treatment did you get at Georgia Injury and Spine?
I believe they did X-ray. And I also was given a TENS unit and a back brace as well.
Okay, Your Honor, plaintiff moves to admit Exhibit 2 into evidence.
2 will be admitted.
Thank you. Ms. McMillan, did you treat with TriStar Injury Center after Georgia Injury and Spine?
Yes.
I'm now going to show you what's been marked as plaintiff's exhibit number 3. This is just one page, but if you'll take a look at this and let me know once you recognize it.
Yes.
Excuse me. Is this a true and accurate copy of the bill you received from TriStar Injury Center of Decatur?
Yes.
Okay. And did you treat with TriStar after this collision?
Yes, I did.
What kind of treatment did TriStar provide you?
Another X-ray as well for confirmation from the previous, and I believe I did receive an injection from them.
Okay. Your Honor, I move to enter plaintiff's exhibit number 3 into evidence, please.
All right, it will be admitted without objection.
Thank you. Ms. McMillan, did you feel like the treatment at TriStar and Georgia Injury helped you with your pain and injuries?
Yes, it did to a certain extent, yes.
Okay, did you treat anywhere else?
I believe it was just TriStar in the previous.
Okay, I'm now going to show you what's marked as plaintiff's exhibit number 4. Do you recall visiting Ortho Sport and Spine for treatment?
Yes, that was a chiropractor, yes.
Okay, and if you'll look through this bill, I want to show you the whole thing. Make sure you recognize it.
Yes.
Okay. Is this a true and accurate copy of the charges and bill you received from Ortho Sport and Spine?
Yes.
Okay. And do you see an account summary and final charges from Ortho Sport and Spine?
Yes. $7,541.61.
Okay.
And also, I do want to say that this place, that you're showing now. I did get 2 injections. One was from them, and then the original one was from the one previous.
Okay. Did those injections help you?
Yes, they did. Temporary relief, I should say.
Did you ever have to wear a brace or orthopedic appliance?
I had to wear a back brace and TENS unit at night because I would have back spasms.
Okay. Were you ever prescribed any medications?
Yes.
Your Honor, I offer plaintiff's exhibit number 4 into evidence, the bill from Orthosport and Spine.
It will be admitted.
Thank you. Do you remember the names of the medications, Ms. McMillan, that you were prescribed?
Not specifically, but I do know that it was 2 muscle relaxers and the last one I forgot what it was for, but it was supposed to help like my muscle spasms that I was having. But I believe it was 3 or 4 medications. 2 of them were muscle relaxers though.
Okay. I'm not going to show you what's been marked as plaintiff's exhibit number 5. This is a bill from Preferred Prescriptions Pharmacy. This one is just 1 page as well. Can you just review this?
Yes.
Have you had a chance to look at it?
Mm-hmm. Yes.
Okay. Is this a true and accurate copy of the bill that you got from Preferred Prescriptions Pharmacy?
Yes. $772.96.
Okay. Your Honor, we ask that plaintiff's exhibit number 5 be admitted into evidence.
It's admitted.
Thank you. Okay, Ms. McMillan, all of the bills that we've looked at today, have any of those been paid by you or by anyone else?
No, ma'am.
Who's responsible for paying those bills?
Unfortunately, me.
Can you tell us a little bit about, you said that the treatments helped to some extent. Can you tell us what you meant by that?
So even now, currently, I still have back spasms. The line of work that I was in, the time of the accident, I worked at FedEx office as a lead supervisor. So I did a lot of lifting and packing, and it kind of put restrictions on and limitations on what I could do at work. Even now, I still have back spasms at night. If I do too much lifting, it'll put a strain on my back where I can feel like literally like a Charlie horse in the center of my back.
How old are you?
29.
How many weeks or months did your treatment for this wreck last?
2 months.
Okay, so you treated until December of 2022?
Yes, ma'am.
Why did you stop going to treatment?
I was having to lose time from work. I wasn't able to keep going to treatment because I started getting behind on bills because I'm losing time at work, having to go get treatments.
How much time from work did you miss?
Within those 2 months, I was leaving work. I was going to treatment almost 3 times a week.
And during your treatment period, did you follow the directions of your doctors?
Yes, ma'am, I did.
Did they instruct you to do any at-home exercises?
Yes, I had to do at-home exercises to strengthen that nerve back up. And I was also instructed that I had limitations on weight that I could pull or pick up. And that also affected home life with my son. At the time, my son was 2, so toddler, I'm always picking him up. So I still had to be a mom.
Definitely. Can you tell us, I'm sorry to jump around, but I forgot to ask you how much your pay rate was at FedEx during the time of the accident?
At the time, I believe I was making 17 or 18 at the time.
Okay. Now, you talked a little bit about how the wreck affected your family life with your son. Can you, and how it affected your work? Are there any other parts of your life that this wreck affected?
Yes, certain things as far as like outings, well, that's still a part of personal, but like certain outings or certain functions I won't attend if I have to walk up a certain height because walking in like an incline, it puts a strain on my back as well.
Did you have any issues with sleep or everyday activities?
Sleeping, especially that first month, was kind of rough. Soreness for sure, and having to sleep with the TENS unit, it would kind of numb my back out, so I would feel my mobility was a little off when I would initially wake up because I would have to go to sleep with the TENS unit.
On a scale of 1 to 10, can you tell us how bad your pain was at its worst?
Definitely a 9.
As we sit here today, are you still experiencing any issues?
Yes.
Can you describe what you currently feel?
I still have the back spasms. Actually, last week I had to go and take off because my back spasms to the point I couldn't even walk down my steps to get out of the house. I had to get assistance to get the pain level down. Nothing was working, heating pads, nothing. When I have spasms like that, it's literally like a mobility lock, and I have to wait for that nerve to subside.
Did you have any of those issues prior to this wreck?
No.
Before this wreck happened, did you exercise or play any sports?
Yes. I had just started working back out as far as like walking and running. And I was doing kickball. The time of the accident, I probably had just stopped playing kickball maybe like a month prior.
Did the wreck affect your ability to participate in working out or your kickball league?
Yeah, I get dressed and sit on the sideline now. I can't. It's sub in when possible.
Did you experience any emotional or mental effects from having to deal with this wreck or the injuries?
Yes, because after the accident and finding out the details of everything of the person's situation, I ended up still losing my vehicle. My vehicle started going down. I wasn't able to drive it. I was having to drive without AC. Whatever cords were pulled were messing with the alignment of my car. It was a lot. I ended up having to get another vehicle in general.
Is there anything else that you would like to tell the court about the way this wreck affected you, or anything else that you want to say that you haven't talked about already?
Just no, that's it.
Thank you. Your Honor, plaintiff rests.
All right. Go ahead.
I'm sorry. I was just going to say I have a very brief closing if you'd like me to give it to you.
Go ahead.
Thank you. The evidence we heard today, Your Honor, shows that because of the wreck caused by the defendants who failed to answer this lawsuit, Ms. McMillan was injured and she sought necessary and reasonable medical care and incurred medical bills. They're documented and they're reasonable. And we also heard her talk about the many ways that this wreck affected her life, her ability to take care of her son, exercise, and just her everyday activities, going to work, all of that was affected. Her medical bills are almost $13,000 total. Excuse me. We would ask that the court enter a final judgment in her favor that not only account for her total medical bills, but also a fair amount for her pain and suffering at the court's discretion, which we believe would be an amount roughly equal to her medical bills. So we're requesting a final judgment in the amount of $25,000. Thank you, Your Honor.
All right. All right. So are you asking for court costs also?
Yes, please, Your Honor.
Okay. All right. So you haven't come before the court and pled, defendants haven't been in default and not challenging those damages pled under oath. The court is going to grant the amount of $25,000 plus court costs. If you send Ms. Powell an order, we'll go ahead and get that out to you.
Absolutely, Your Honor. Thank you very much.
All right. Thank you.
May we be excused?
You may. Thank you so much. All right. Next case is Field versus Reindeer Remodeling and Willie Pittman. All right, so Mr. Samuel Fields and Mr. Fields, you're still muted. And Mr. Pittman.
Yes.
Yes,
All right,
ma'am, I'm
so
here.
Mr. Pittman, let me understand. Reindeer Remodeling is your company?
It was.
It's no longer in, like it's no longer active?
No longer active.
Okay, so it's Fields versus Pittman at this point. Mr. Fields, tell me why you're here, sir. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. All right, so Mr. Fields, tell me what's going on.
On March 1st, I contend that I went into contract with Reindeer Marlin and Mr. Pittman. And
March 1st of what year, sir?
March 1st of 2024.
Okay.
And I went into contract with Mr. Pittman to do some upgrades on my house. And we signed a contract. I think it was about 38,000 or something like that for the original contract. Once the work started, he was supposed to remove.
Let me ask you a couple questions.
Yes, ma'am.
One, did you okay, so when you said you entered into a contract, let's talk first about what the scope of the work was. What was it that Mr. Pittman's company or Mr. Pittman himself was supposed to do at your house?
They were supposed to remove the walls.
Interior?
Interior walls.
Okay. How many?
The interior walls included the walls in the kitchen and in the living room and in the formal dining room.
So
and
you
it's
were
like
basically
eating kitchen.
trying to open it up into an open plan.
Yes, ma'am.
Okay.
They were supposed to have create a laundry room.
Mm-hmm.
They were supposed to create a bathroom.
Mm-hmm. All on the same level?
All on the same level.
Okay.
And on another level, they were supposed to install some floors
Mm-hmm.
and the stairwell. And they were supposed to install a countertop, a countertop on the kitchen island.
Mm-hmm.
And they were supposed to install some doors with associated with those rooms. And they were supposed to do some what you call that molding, the crown molding.
Okay.
In those rooms.
All right.
And they're supposed to create some lighting, some LED lighting in the rooms, remove the old lighting and put the LED lighting in there.
Okay.
Mr.
Okay, that's the scope of the work.
That's
How
the
long
scope.
was this supposed to take?
This was supposed to take 1 month.
Okay.
But they never did complete the job.
Okay. All right. So did you pay anything at what amounts have been paid and at what intervals?
At the beginning, the agreement was to pay half of the $38,000, and I gave him approximately $18,000.
Why were we paying half for work not done yet?
Yes.
Why?
Because that's what I agreed. He said he needed the money to start. And so I gave him the $18,000.
Look at my face, Mr. Fields.
I see. I
Look at my face.
Yeah. I went into trust mode. And I gave him the $18,000. And then shortly after that, he came back and said he needed more money.
Of course he
And
did. Had he started anything at that point?
Oh yeah, he had started. They came in And the first thing I asked them to do was remove the walls, but instead of removing the walls, they covered the walls. And then he came in and told me that they were gonna he was supposed to install a countertop, but he wanted me to go pay for the countertop. And so I had to go to Home Depot and get all that done myself. But that was supposed to be
Hold
on
on,
his.
Mr. Fields. Ms. Goldberg,
Yes, ma'am.
if you're gonna talk, or if somebody else is talking, could you step out of the room? Are you talking or is it the lady behind you?
It's the lady behind me, baby. Lady
All
behind
right.
me.
Is she on a video court?
And it's turning the screen around.
Is Miss Janice in there?
Okay.
We all in the same room.
I got you. But I'm
Yes,
wondering
ma'am.
if the other lady is on, who
Oh,
else is in the same
she's
room?
just radiating off of,
That's behind me.
yeah. So
Okay,
it's his computer that you're hearing her voice on.
I got that. Is this other lady on this, is she in
No,
for me or for some other judge?
she's on the random call.
Okay, ma'am, in the flower dress?
Right here.
Okay, if you're gonna be on a call, can you step out for me while I'm trying to hear them?
Hold on, please.
All right, go ahead, Mr. Field. So you paid $18,000. So how much of this 18,000? So when somebody says, I need half to start, one would assume that materials, that's a purchase of materials to get started.
Yeah. Yes.
Okay, so how much of this was materials versus labor?
I don't know. I assumed all of it was for materials. I gave him the
Did he
money.
give you a breakdown of what the materials would cost to get started? Like, so he's saying, you're asking him for all of these things.
I'll ask him for all those things. And he gave me a contract.
We know what sheetrock costs. We can price sheetrock. We can price the Corian quartz or whatever that you're choosing for the tabletops. We can price whatever the lights and stuff are gonna be. We can price the flooring. All of those things that can be priced and invoiced.
That's right.
Did you all do any of that?
No, he bought me what he was gonna do, and he said, "This is how much it's gonna cost." And I said, "Okay." I said, "You sure?" And he said, "Yes, that's what he was gonna do."
And then the next thing he asked you for was for money for.
He asked me to get money for the countertop.
Okay, how much was that?
That was well over about $6,200.
What you have? Gold fleck granite? What you
No,
have?
it was quartz.
Okay.
It was a quartz counter. Well, it was not just, it was a quartz countertop for the whole kitchen.
But you said for the island. So now we expanding the scope of work.
It was the island and the countertops.
Okay.
For the kitchen. Right. I'm sorry, I said the island, but I did say countertops.
Okay.
It was for the island and the countertops. And so it was over $6,200. So I went to Home Depot and I paid them the $6,200. And they came and they sent their own people over there to install it. So he never did do that, but that was on the contract. And so he was supposed to put flooring in one of my top bedrooms. Well, he put the flooring in, but then I told him everything needed to have the LVP flooring. I can't hear you. I can't hear you.
Hold on. You paid him $18,000 to get started on the job.
Right.
Then you went to Home Depot and paid $6,200 for a quartz countertop.
Right.
But Home Depot did that part of the job. And you paid them separately.
Yeah, I paid them separately.
Okay, so that's part of the scope of work that he did not do and was not.
He did not do that, right.
Okay, So what was the next thing that happened?
The next thing, he covered the wall, but I wanted them to remove the walls. When I said I wanted them to take the walls out and put it and take it completely out and put another wall in there. Instead, he covered the wall.
Mr. Fields, where's the written document where y'all went over this and wrote it down?
He has a contract.
Mr. Fields, you paying the money, but you don't have a copy of the contract?
I did have a copy of the contract, but I couldn't find it. And I gave him yeah, that's my fault. I could not look. I got other parts of the contract because he did what he called he wanted to do more work.
Okay,
So
let me ask you this. Was this a property that you lived in, or was this an investment property?
It's a property I lived in.
Okay, and you said you wanted him to tear down walls to do a demo. That would assume that we're looking at what's a load-bearing wall, what can be torn down versus what can't be torn down.
Now, when I say tear down the wall, it's not poles. It's actually sheetrock.
I get that, but okay, so let me make you understand. I come from a construction background.
Yes,
when
ma'am.
somebody says they want to tear down a wall, that means the wall no longer exists. I'm looking into the next room.
Right.
But not, I want to change the sheetrock or I want to repair the sheetrock. I'm talking the joints, studs, everything is gone and there's no wall there.
Well, that's what my intent was, for him to have everything removed and only the down to the studs. And
you're living in the house and
Mm-hmm.
at some point you come in and there's no demolition done. So what happens at that point?
He told me that he was going to cover the wall. So I
how
just
he
let
gonna
it.
tell you what you paying him $18,000 already on a $30,000 contract, and he's telling you what he's gonna do?
That's what he said. He's going to cover the wall. So I just let that go.
Why, Mr. Fields? Why are you letting that go?
Because I trusted it. I thought it looked fine. I just let it go.
Okay, so you said the court's work, the countertop work was done by Home Depot. What's the next thing?
Yes. The next thing was they created an arch. It was like an arch in the wall.
In an entryway, yeah.
Right, in the entryway. And they created they did cover the walls. They did and put sheetrock on the wall.
Okay, so instead of tearing down the wall, which is what the original scope of work says,
right,
they are covering the wall with sheetrock.
Right, that's what they did.
And telling you got to choose a paint color.
Right, and they were supposed to paint, and that's the other thing.
For walls that should not even have been there.
The walls shouldn't have been there. It should have been walls, but they should have put new sheetrock there and painted the walls.
Okay, see, you're confusing me. I said, when you tell me remove the walls, that means the walls are gone and I'm looking at an open room, open space.
Right.
From one room to the other.
Right.
Was it your intention for them to redo the sheetrock or?
Right.
Okay, that's not what you said.
Okay, I'm sorry. I told them to remove the walls and repair and replace the walls. That's what it was. They were supposed to remove the walls and replace the walls.
Did they do it?
They didn't do it. They covered the walls.
Okay.
All right.
We strip the walls down and all I'm looking at is studs.
Yeah, that's what my intended, but that's not what they did.
So they just put sheetrock on top of sheetrock.
Right.
That's not right.
Okay. All right. Okay, Ms. Goldburn, I can hear you, and I shouldn't be able to. This is not
Can you
your.
hear me? Can you hear me?
Yes, I hear you, Mr. Pittman, but Ms. Goldberg, this isn't her hearing yet, unless I'm mistaken, so I shouldn't hear her. Who else is talking in the room?
Oh, they back
He
there.
had said something underneath. He had said something underneath his breath like that.
Okay, let's not do that. All right, so so sheetrock on top of sheetrock instead of replacing.
Right.
Okay, what's next?
All right. The next thing they were supposed to do was they were supposed to create a bathroom and a laundry room.
Okay.
Neither one of those were completed. They're supposed to install a stove that I went and purchased.
Okay, when you say create a bathroom, let's stop right there. You said, so for me, when you say, because this is the problem we had before, you said take away the walls, but you didn't explain you wanted them
Right.
recovered.
Replace.
So,
Yeah.
so
Yeah.
walk through
I
this.
got it. All right. Let me
You
explain to you about
said,
this part.
now hold on. You said you wanted a bathroom. What area of the house are we talking about?
It's a hallway, and it was one big room at
Okay,
first.
so
It
you
was one
wanted
big
that
room. So I wanted those.
subdivided
Right. And then
into a bathroom and a laundry room.
That's correct. That's
Okay,
correct.
was it already piped? Was the plumbing already there?
The plumbing was there, but it had to be moved.
Okay, so
And they it was no wash machine there at the time. And the commode was there, and a sink was there, but all that had to be reconstructed.
okay, so you want them to demo that, and you have now said make this 2 rooms, one a
That's right.
bathroom and one a laundry room.
Right.
Okay.
And right
What
next to it, they made it was the pantry, and they made the pantry a little smaller, and that was intentional.
Okay, now tell me what happened. What is the state of the bathroom that should have been constructed?
It was never completed.
What?
The commode was moved, the sink was moved, but it was never reinstalled.
You mean the connections for the commode?
No, the
moved.
actual commode was moved, and the actual sink was moved, but it was never the plumbing was never put in the right place for it to be installed. Now I have pictures to show that, and also it was the plumbing for the laundry room was not completed.
Okay. All right. So that job is still like that.
It's not like that now because I went and hired somebody else to do it.
Okay. All right. But you have pictures of how it was left.
Right.
Okay. And what was the time frame? So you said all of this was supposed
All
to
of this supposed to be done in 4 weeks. That's what she told me.
All right. And so at the end of 4 weeks, your bathroom was left undone. Your laundry room was not functional.
Laundry room was functional, and we didn't have they had taken the cabinets off, but the cabinets were in the garage, and they never were put back up.
All right. So let me go over the scope of work you gave me. So we've already talked about the walls. And you said that sheetrock was placed up instead of the taken down to the studs and re-sheetrock. Okay. Then you said they didn't create the laundry room. They didn't create the bathroom. So they didn't complete those.
That's right.
Okay. So your next thing is you said they were supposed to install floors. In what area?
The floors were supposed to be installed in the upper bedroom, and they did complete that. Another contractor, I guess through him, it came and completed it. But
so they subbed out the floors.
Right.
Did you have to pay additional money for that?
I didn't have to pay the additional money for the floors, but he came back and told me that they weren't going to do the rises, the stairs going up there.
Right.
And I told him I wanted all of that done.
Okay.
And then he came back and told me that he needed more money to have the stairs done because I said, well, I told you I wanted everything done, and he said, well, you know, he didn't think I needed it. He came and told me. He said, well, I know you said you wanted all of it, but I didn't think to do it. And I said, well, what do you think all mean? I mean, everything.
Okay, so yeah, it's better if this is written out in the contract. That's why you have contracts. So that when one party says, I didn't think to do it, then the other party can go and put his finger on the wording that says, this is what we agreed to in writing.
Yeah, if he's got a contract, it's the contract. I guarantee you he's got it. He should have it if he had a business. Huh?
So he failed to do the stairs like you agreed. So you say,
Well, the stairs was done, but I had to pay extra for that.
How much
So
extra?
a little over $9,000
Excuse me? To do stairs?
To put the stairs in there. To cover the stair for materials and labor.
Okay, let me ask you this, because this is where we get into the weeds. Were there stairs there when he started the job?
Yeah, the stairs were there, but they
So
were
he
carpeted.
didn't, hold on. So he didn't have to create stairs. He
No.
just had to remove carpet and put flooring down.
That's right.
And you paid $9,000 for that.
That's what I did.
Mr. Fields, do you talk to anybody else and ask them, is any of this reasonable?
No, because I trusted him. I just moved into the area, and he said he could do it. I trusted
You didn't
him.
do no comparison shopping.
No.
You just picked Mr. Pittman and said stairs, and because the reason I'm asking is my husband did our stairs, and I know it did none of that. Even the materials didn't even come no close to no $9,000. I just like I'm about to send him over to your house if you need more work done because he got some time on his hands. If you paying like that,
But that's what I did.
okay. So that's not so that's 9,000 in addition to the 18,000 you gave him to start.
That's right.
Okay. What was next?
Well, they were supposed to do the lighting, and they did do the lighting. They did do some of the lighting, except for in the laundry room and in the bathroom. And they were supposed to paint. They later painted. I think they contracted somebody to come paint it, but they wanted me to pay another $3,000 for that. So the person came and paid, and I paid $3,000 for that.
Wait, you paid, okay, hold on. So you paid, so you understand what scope of work means? Like if you contract with somebody and you say to them, this is what I'm paying you to do, and this is how much I'm gonna pay you to do it. And then every time you turn around, you're paying an additional person to do what you already paid. Why? Why you keep doing that?
I can't answer that, but I did.
Okay, so this is why I'm asking you these things, Mr. Fields, because at some point we have what we call a novation. In the law, a contract is a meeting of the minds. And so if you and Mr. Pittman agree to the scope of work, that's why I'm breaking all this down, and the amount of money and the duration of time at the beginning of the job, that's the contract. When you start agreeing to variations in the contract, that beginning thing is no longer the contract because you're agreeing to it. So you're agreeing to novations. If he says, I'm gonna need $9,000 more to finish your stairs, to do the stairs. And you say, okay, well, it was in the original scope of work, but if you say I need to pay you $9,000 more to do the stairs, that is what's called a novation. Because he's saying, this is what I'm gonna need. You already know you've already asked for it in the original contract. But if he offers, I need $9,000 more, and you say, okay, and you pay it, you have done a novation. You've created an entirely new contract with new terms that you're abiding by. Okay. So the reason I'm telling you this is because I assume that the purpose of this hearing is for you to get some money back from Mr. Pitt.
Right.
But if you agree to these things because you went ahead and paid it, you can't get that money back because that is a novation of the contract.
Okay, I understand that, and I do, but I want him to pay me for not finishing the kitchen. He didn't finish the kitchen.
How much did you pay to get the kitchen finished?
I paid, in all, I gave him a little over $56,000. $56,000.
Mr. Fields, you have a wife?
Yes.
Did you talk to her about any of this? Because when it comes to spending money, we talk about stuff. We like, you sure? You sure you don't want to ask anybody else? She didn't say any of that.
Yep.
She did.
She did.
And you told her, baby, I'm the man. I know what I'm doing.
No, I told Mr. Pittman, he knows he's put me in a hard spot. And he knows it.
No, sir. You're not gonna blame Mr. Pittman for that.
I know, but that's why I didn't bring it up.
In your pocket.
Uh-huh.
Okay, tell me again, because a lot of this stuff you've agreed to. You've done novations on the Home Depot. When you paid Home Depot, the materials and the labor, that was a novation.
Okay.
And you paid for the stairs separately. That was a novation. When you paid the painters $3,000, that was a novation. So you agreed to pay Mr. Pittman extra money. It's like every time Mr. Pittman came and put his hand out, you put money in it. I'm about to go get my HVAC. You need HVAC? Yeah. I'm about to go get my certification for. I can do sheetrock. I know how to mud it and everything. You need anything else done? Because if you pay it like this, that's an issue. So, okay. So now the things that you had to pay to have finished that were still part of the original contract.
Right.
The bathroom, the laundry room, the kitchen.
And kitchen.
How much did you pay someone else to finish those amounts?
I paid them a total of $25,000.
So in addition to putting $54,000 in Mr. Pittman's pocket, you then also paid an additional $25,000. You could have bought a house for this. $25,000.
Right. And I gave him $25,000, and that was.
Who did you have finish the work?
I had two contractors. One was a past construction company, and the other one was what's the name of it? Max Construction Company. And they came in and they finished the work on the crown molding, and they completed. It was something else he was supposed to do. He was supposed to do the fireplace. I'm sorry, he's supposed to finish the fireplace on there. So they took the fireplace out, but they never did put the fireplace back. So the fireplace was left undone. And so that was another thing they didn't do.
Okay.
And so the fireplace, the kitchen, where they're supposed to put the stove and the dishwasher and all that, none of that was completed.
Okay. Do you
the
have
laundry room? I'm sorry. The laundry room.
I was just going to ask if you have invoices from the other companies that you paid to get the work done that should have been done under Mr. Pitt.
I do. I don't have it with me now, but I do have that.
Why would you come to trial and not have the?
Because I didn't know that they were they would be a factor in it. But I do have.
Fields, this is a trial. You're asking me to award you money that you paid because you're saying that the work wasn't done and you had to have somebody else do it. What did you think I would be asking you for? You don't have your contract with Mr. Pittman. You don't have the invoices or paid amounts that you paid to other contractors to finish the amounts. How you come to court and it's your case to present and you don't have any evidence?
Well, I do have something, and I do have some of the contracts I paid him.
Some of the what you paid him?
I have the checks. I have the.
I don't doubt that you paid him. The problem is what you're asking me for is the difference between the work he should have done and the work you had to pay somebody else to do. That if you paid somebody else to finish the job, that's the value of what you're asking me for.
Right.
all of those other things where you say, well, I'm gonna give you some extra money. You let so and so come in here and do this work. I'm gonna pay them this extra money. That was you creating a novation of the contract. So you created a whole new side contract. You didn't hold him to the terms of the original agreement saying, you
Right.
agreed to do this. I'm not paying anybody else to do this. You need to
That's
get
right.
this done.
That's right.
You
And
just kept giving out money.
And you're right.
I know, and like I said, I've been doing this for 9 years and I got a construction background. So I'm clear on what's supposed to happen. I don't understand how people keep doing this though, just throwing money away instead of, if you went to get tires on your car, you would say, okay, I need 4 tires. Okay, let me call a couple of places and see if they have the particular tire I need and how much it's gonna cost me. I wouldn't just go to the first place that's got tires. But this person comes into your house and you say, okay, I need you to do the work. And at the first sign that they're not doing the work, you just give them more money.
Yeah.
Okay, so you don't have any invoices from the other people who did the work.
No, not with me.
Why not? Okay, you at your house. Presumably, why would you
Well,
have that?
I'm not at my house. I'm actually in Orlando, Florida. And when they said this was gonna be virtual, you know, I didn't know I was gonna have to present their information also. But
You don't even have the original contract. This is what I'm saying.
mhm,
You are wholly unprepared.
yeah.
Mr. Pittman, tell me what's going on. Raise your right hand
Yeah.
for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right. He says you didn't finish. You put your hand down. He says you didn't finish the work and you used subs that he had to pay separately. What's going on? Put your hand down, sir.
Everything that he said is absolutely wrong.
Okay.
The thing that it was, his house, we went there, they wrote these whole things all over the wall. The whole back wall was rough all the way down. And he didn't like the way it was. It was nice and beautiful. So we said we were going to skim it at first.
Okay. So
To
what
make
you're
the
saying
walls-
is he had some kind of treatment on the walls that made them like
rough
like
all the way
popcorn sticks.
around. Yeah, it
Okay.
was decorated
So
all the way around.
he wanted you to take the sheetrock down, re-sheetrock it, and paint them.
No.
That's what he's saying.
That's what he's saying.
What does the contract say?
The contract said we was going to skim the wall and take the popcorn out of the ceiling. I got it right here.
That's right.
Read to me what what it says.
Show it.
All right. And the reason we went there to look at it is to remove.
No, Mr. Pittman.
No.
Yeah.
I don't want you to tell me what you went to look at it. Somebody's got to give me something in writing that y'all met at the time and y'all agreed to something. So tell me what the paperwork says.
This is what I said.
Okay, read it to me.
Is there remove decorated ropes off the cabinets and remove backsplash and repair?
That's the kitchen.
That's the kitchen. And the wall was to be skimmed to make them smooth all the way around.
No, he needs to show that.
Okay.
Because it says replace and remove.
Hold on, Mr. Fields. You can't tell me what it says because you don't have a copy of it.
I know it. I know what it says. But go ahead.
That would be helpful if you had a copy.
I wish I did.
Mr. Pittman, hold the thing up to the screen and let's see if I can read it.
The whole thing.
It's not. Hold on, Mr. Fields.
Okay.
You can't be a shot caller because you could have had this yourself.
Yeah.
All right. Yeah. I put it all. Bring it a little closer. Yeah, I can't read that. Hold on a second. Hold on just a second. Just hold it like that. Hold it up. I can read it now. It says, remove popcorn from ceiling, take out sink, hold it over a little bit to your left. There you go. It's right there. Stop. Okay, so what I'm seeing, hold on a second. Don't do anything yet. Spotlight. Okay. Kitchen cabinet work, countertop removal and replace. Remove all rope designs on all cabinets. Remove backsplash and replace. Remove all walls in kitchen. Replace all walls in kitchen, living room, dining room, and laundry room. Remove popcorn from ceilings. Take out sink. Take out toilet to reframe laundry and hallway. Reroute washer plumbing and dryer electrical connections. Remove fireplace hurts and replace with a new smokeless fireplace. Close in one bookcase to make a closet. Repair flooring. Okay, yeah, Mr. Pittman, it does not say what you said. It says replace the walls, not skim.
That's right.
The reason.
Okay, Mr. Fields, I done heard from you now. Go ahead and mute.
Okay.
Because
Right.
you had your chance to show me the contract.
Right.
Okay, so Mr. Pittman, why are you telling me the wrong thing? That's not what y'all agreed to.
There was no what the wall that he was talking about.
Mr. Pittman, come on now.
Yeah.
I've been dealing with construction a long time. Yeah, I know it would take longer to remove all of that and replace it with new sheetrock. You decided you were just gonna scrape it off and or sheetrock over it. That's not what the contract says, though. It says replace the walls.
This is one wall that's in the kitchen.
No, it said no.
Wall,
No.
What you read was what he said about how many walls. So it said replace the walls, and it said replace the walls in kitchen, living room, dining room. That's on the contract, sir. So tell me why it wasn't done. Mr. Pittman, you do not want to be that person that people always talk about contractors are bad.
no,
So tell me why that work wasn't done.
the work was done. Because
What was done, sir? Did you take the walls down to the studs?
Excuse me?
Did you take the walls down to the studs? Did you remove the sheetrock and expose the studs?
The wall that he wanted was taken out was in the kitchen area. This is the wall in the kitchen area that he wanted taken out to make an opening so his wife could be in the kitchen and look in through from the kitchen to the living room.
Okay,
And
where on the contract does it say skim the walls, Mr. Pittman?
we told him that at first he said about.
Oh, no, Mr. Pittman, you still not answering my questions. First question I asked you was, tell me did you take it down to the studs? You still haven't told me that. The second question I asked you is,
We did take it all down to the stud because it'll cost more money than what
okay, but he's paying, obviously he got money. If he said that's what he wanted, then that's what he wanted.
Our agreement.
Did you underbid the job?
$36,000.
You what?
For our $36,000.
That's what you told him you would do the work for.
But I told him what to do to work. And
okay,
or,
Mr. Pittman.
Yeah.
Okay, first of all, both of y'all are driving me crazy. This is the problem because there was no clear meeting of the minds in the original contract. Mr. Pittman was going to do one thing, Mr. Fields wanted another thing done, and every time they talked, y'all were talking past each other like this. Mr. Pittman, in his contract and knowledge, said, well, I'm not going to take down them walls. I might as well just throw another thing of sheetrock over there or scrape them down. That's just going to be cheaper based on what I quoted him for. So that's where he was. Mr. Fields is thinking he's going to tear them down to the studs so you can see through the walls. And then that's what Mr. Fields said. Then he's going to put up new sheetrock and paint. So y'all didn't understand each other from the beginning. It's amazing anything got done. Second of all, every time y'all talk, you threw in another sub or somebody else had to get paid, and he's handing out money to subs that weren't a part of the contract. So there's no contract for the court to decide. There's no way I can come down on one issue or the other because y'all never had a meeting of the minds. A contract consists of a meeting of the minds between both parties. Offer, meaning I'm offering to do this job for this amount of money in this length of time using these materials, all the specifics. Then acceptance. I'm going to do the job and I'm going to be able to
Hello? I can't hear. We've lost some type of connection. I can't hear.
Okay, so yeah, y'all never had, in order for me to decide on a contract, if somebody breached a contract, there actually has to be a contract. In this case, y'all from the beginning did not have a meeting of the minds. So there was never.
But Judge, we had a contract. The contract he has
No,
is what?
Mr. Fields, just because you wrote something down doesn't mean y'all understood it.
And we
Neither
signed
one of y'all was working from the same, even what's on the paper. Neither one of y'all were working from the same piece of paper.
No, we were working from the same. I told him what we had on that contract is what I wanted, but that's not what he delivered.
Mr. Fields, that's not what you paid for either. You paid for different stuff. He was supposed
but
to
those additional things. Yeah, but
no, sir.
But he never did replace the walls.
Okay, I'll give you that.
He covered the walls, and he never did finish the kitchen.
This is
he never did finish the back.
Mr. Fields.
Go ahead.
This is the other part.
Mm-hmm.
I don't have any way of knowing the value of each part of your job because y'all didn't cost it out. And that's what I'm saying. Mr. Pittman knows you can cost out a job. You can cost it out based on what the labor is. You can cost it out based on what the materials are going to cost you. When you make certain choices, okay, I'm choosing quartz. Okay, so this amount of quartz is going to cost you this amount of money, especially if you choose this particular one. Part of coming to an agreement in the job is I'm picking this type of quartz. This type of quartz costs this amount of money per square footage. We're going to cost that into the job, and then I know what labor is. Y'all didn't even cost out the job. He had a list of things on a piece of paper, and he said, give me $36,000.
And that's what I assumed he knew what he was doing. He's the contractor.
Mr. Fields, you can't just throw thousands of dollars down the field and say, I assumed he knew what he was doing. Did you check any of his work before? Did you see any of his work for anybody else?
No.
Did you find out if he was rated with the Better Business Bureau?
No.
Did you determine if he had ever done this work before ever in life?
No.
Okay, so what were you trusting?
He told me, and he seemed to be an honest person. Right now, he's trying to lie his way through it, but he seemed to be an honest person, and so I took him on it. And I should have listened to my wife and not deal with it. But
I knew in there somewhere was a wife who told you the right thing. Y'all don't listen to us. I knew somewhere in there was a wife who told you the exact right thing to do, and you didn't listen. And you know what, Mr. Fields?
But I'm disappointed in him more right now because I know he's not telling the truth. He knows it.
Unfortunately, Mr. Fields, the disappointment is going to be about where we stand on this, because when I say there was no meeting of the minds, there was not a meeting of the minds in this case. Because if there was a meeting of the minds at the point where he didn't take those walls, let's assume that was the first thing to be done. At the point where he didn't take those walls down to the studs, then you didn't stop him and say, hey, this is what the contract says. You didn't take the walls down to the studs. We need to stop right here and look at what the contract says, or else you will be in breach of contract. You know what you did? You said, okay, I'm going to just go with it. That was a novation. So what I'm saying to you is at every point that you could have enforced a contract, you didn't.
Not every point.
At every point. That first point where he didn't take those walls down to the stud and you understood that that was what the scope of the work was, you let it go. I just accepted it. Mr. Fields, what'd you do for a job, if you don't mind me asking?
Well, right now I don't do anything for a job. I'm retired.
I figured you were retired. What did you do before?
I was in the military for 24 years. I worked as a government IT professional for another 10 years.
All right. So in the government, you familiar with procurement?
Yes, I am.
Okay. So the government has the benefit of paying for stuff because they have preferred vendors and things. But they basically going to do an RFP. They're going to list it out and they're going to say who can give me the product I want for the right amount of money and make sure the job gets done, right?
Right.
Okay. You spent money without doing due diligence. You didn't do an RFP. You didn't find out whether he could do the work. You just decided, Mr. Pittman drove by, you waved him down and said, hey, I got a good $75,000, $80,000 in my pocket that I'm dying to get some work done. Come in and get started. I don't have a contract from which I can make a determination because all of the terms are uncertain. Y'all never got clear on terms. You never agreed fully on the scope of the work. You never agreed fully on what would be paid, when would be paid, what would be done in what frame of time. I'm going to do all of these things in 4 weeks instead of, okay, the walls are going to be done in a week. I'm going to do demolition by the 3rd day, on the 5th day. All of those specifics that a contract requires, y'all don't have any of them. And then every time he would have breached some portion of what y'all did have, you let it go and said, okay, I'm okay with it. And I'm gonna keep paying you money. I'm gonna pay you more money. So at this point, the court cannot rule in your favor because there was no contract. There was no meeting of the minds as to the terms and conditions between the two of you for the work that was supposed to be done. So at this point, I find in favor of the defendant, Mr. Pittman, not because he did it right or because he didn't breach. It was because there was no contract to breach. Y'all were never on the same page.
I just know he's
okay. Hold on, but Mr. Pittman, you've been working a long time, and if you've been working in this field, you know that this was not reflective of what you should be doing. You know better. My grandfather was one of the best general contractors I've ever seen. And when I tell you, there's still houses standing where people proudly display his work. It's all about your name and reputation, sir.
Understand.
It is all about your name and reputation. All right. So at this case, at this time, the court finds in favor of the defendant because there was no contract for which a meeting of the minds ever occurred. So there's nothing for the court to decide on. All right. Okay. And Mr. Fields, please next time do some comparison shopping and listen to your wife.
I just know I want him to know he's a bona fide liar. And
okay.
He knows it.
Well, I'm sure he got out of it what he needed. Unfortunately, that was to your detriment. But one thing I want to point out is, and this is for everybody, when you make a bargain, make sure you're clear on the terms of the bargain because nobody can take advantage of you unless you let them. Mr. Pittman could ask you for additional funds, but you paid him. And you never said, nope, not going to do it. No other dime is coming out of my pocket until you do what you said you should have done. You could have stopped at any point, Mr. Fields, but you kept throwing money at the problem.
I did, and they stopped coming. So I stopped coming to work.
And
he knows that. He knows that. And I did.
Okay. But you did it after you were $54,000 to the
right
in on a allegedly $36,000 contract. Okay, so that's what I'm saying to you is the courts can't fix everything. There has to be something for us to fix. All right?
Okay,
Okay.
Your Honor. Thank you very much.
You're welcome. All right, last case is In-Town Suites Management versus Marilyn Goulburn and all
Yes, ma'am.
others.
Yes, ma'am.
Can we be dismissed?
Yes.
Judge, I'm sorry. Just briefly before we hear that case, I see that Miss Marlene Corcoran has joined the
I've been here.
hearing.
Thank you.
No, not Miss Goulburn. Miss Corcoran
Okay.
has joined the hearing as well. I don't know if at least I saw her for a moment.
Huh.
But then additionally, the motion for publication that we spoke about earlier.
Yes.
The statute of limitations runs today, so I don't know if you want to take a minute to sign or if you'd rather just sign that ad hoc.
I can sign it in a few minutes when I get off this. Do I need to sign it right this second?
If I don't file it by before the clerk's office closes, it won't count as being filed today.
All right. Did you send it to me?
Yes, ma'am.
Okay. All right, Ms. Corcoran, we called you. The California casualty never showed up, so the case was dismissed.
Oh, okay, because I was having a problem trying to get in, so I
I
didn't
got
know.
you. Yeah, they didn't show up. So, Miss Powell, I don't see it yet.
Yes, ma'am. I'll resend.
No, I don't think you have to resend it, but I do keep refreshing. So let's see. Yeah, I don't have it yet.
Yeah, it would have been a while ago. I'll do it again.
Okay, let me see if I
might not have, Judge. I think you might have called me and I might have got distracted. So forgive me.
I don't have it. Okay. All right. So yeah, Miss Corcoran, you're free to go at this time. Miss okay. So the next case,
Miss Goulburn.
Miss Goulburn. Second. Here we go. All right, so this is In-Town Suites Management, Inc. versus Marilyn Goulburn, and this is a over/dispossessory proceeding. Okay, it says that defendant refused to take payment one day late, and then an eviction occurred. So March 3rd of 2025, a dispossessory was initiated. The defendant was served on March 4th of 2025. The defendant answered on March 7th, and March 21st, 2025, a motion to compel payment of rent into the court was filed. Rule NISA for this hearing was filed on April 16th, and now we're here at the hearing. All right, so Mr. Richard, tell me what's going on.
Yes, that's correct, Your Honor. Thank you. Thank you for that. I enjoyed the 1L lesson on contract formation, by the way. Took me back.
I know, right?
So yes, we're here on a motion to compel the payment of rent. We've got in the motion itself, we have the affidavit of Brianna Lowe, who's also here on the Zoom today. But through her affidavit, she has attested to the rental rate. You've got a copy of the lease there. You've got
okay, so just for the record, let me make sure I'm clear. So In-Town Suites, I assume to be a day-to-day hotel rental.
Correct.
Okay.
Well,
is there
weekly also? Well, it's weekly starting off, and then you have an option to do daily if you can't do weekly.
Okay.
Correct. So it is an extended stay hotel, and the easiest way to show this is through the folio that's attached as Exhibit B to Ms. Lowe's affidavit with the motion. Ms. Goulburn started out as a weekly tenant.
Okay.
And at the end of January 2025, January the 29th, this is on the second page of the folio, she switches to what is called the stayover rate, or daily rate, if you will.
Right.
a daily rate for rent plus a daily technology fee for a total of the $69.30 per day that InTown sought through its complaint. She, as you'll see in the folio, she paid through February the 3rd, but payments were late on January 30th, the 31st, February 1st, and February 3rd. The only reason it wasn't late for February 2nd is that on the 1st, which was a weekend day, she paid for 2 days. It was the late payment that resulted in InTown's decision not to rent to her any further, and that decision was announced to her on February 4th when she came in to make her rental payment. Now, the lease itself, which is Exhibit A to the affidavit, makes clear that the guest agrees that they're moving out at the end of each rental period and will be moving in only if management InTown accepts payment for a new period. The term of the guest's stay is 1 period, as defined herein, regardless of whether or not the guest's belongings have been removed from the room. So as we went from February 3rd to February 4th, her rental period at that point, as shown by the folio, was a 1-day rental period. She was on the stayover rate. And at that point, having made a series of late payments, the decision was made to non-renew her and not to accept her payment. At that point, InTown sends the file to me. I send the February 19th demand letter, that's Exhibit C, to Ms. Lowe's affidavit submitted with the motion, that gives notice of a demand for possession and includes the posting requirement under the revised landlord-tenant statute. And the affidavit also reflects the posting of that notice, where she had 3 business days to pay all amounts then due in full to avoid the filing of the dispossessory complaint. And as shown in the affidavit, she did not make payment within 3 business days. That was by February 25th. Did not make any payment, and here we are. She has answered the complaint, and the issue of possession was not fully resolved within 2 weeks from her date of having been served, which is why we filed the motion to compel the rent. She did not respond to the motion to compel the rent. That response was due by April the 24th, and we didn't get anything, and the docket doesn't reflect any filing.
Is she still in possession of the property?
She is, as asserted in the affidavit, yes.
Okay.
So at this point, the weekly amount due, we had submitted a proposed order at the time. I've prepared an updated one that just runs the numbers forward. But taking the daily rate of $69.30 a day multiplied by 7, that's where we get $485.10 per week. Because the way we typically do these is the court enters an order that requires the tenant to pay into the registry weekly rather than daily. It's much too inconvenient to require somebody to show up at the courthouse every day. So we've got a weekly rate of $485.10 from February 4th through yesterday, which would be a complete week. That's 14 weeks at $485.10 equals $6,791.40 that we are asking be paid into the registry within 10 days of the entry of an order. And then each week after that, a weekly payment is made into the registry. We're not seeking disbursement of the funds at this point. It would be held in the registry pending further order of the court at this point. But that's
so, are you seeking dispossessory at this point, or just that she pay into the registry?
Well, we're seeking dispossessory through the complaint. The Rule 9 side that we received, we interpreted as this was a hearing on the motion to compel. Happy to present the entire case, and I have Ms. Lowe here in case.
Yeah, because there's no reason to parse it out. I mean, if she hasn't already paid into the registry, the likelihood that she's gonna pay, and then we set another hearing date, you're not getting paid. She's still in possession of the property, and the issues aren't resolved.
Sure.
So it would be inefficient, judicially inefficient, to parse this out into some bifurcated thing. Okay, so Ms. Goburn, in your answer, what do you feel is the reason you should not be evicted from the property?
Your Honor, this is my thing here. I was falsely evicted. I normally pay. I've been there since 2018. I normally pay on time. When it came down to me paying daily, I would pay daily and I would pay my late fee. The day that I came in to pay him that evening on the 3rd, when I came in to pay him, I was like $17 short, okay? I had a card on file that my auntie put there for me to normally, if I need a little change, to take it from my card. But he did not want to use the card. The new management didn't want to use the card because he just came in on 2025. The other management was gone. So the new management that came in refused to use the card because he needed the card itself. So he called the policeman on me. The Clayton County police came out. I got his card and everything. The police said, well, sir, you can't throw her out. You have to evict her. So he said, well, just go ahead and give me her money. I went on ahead, gave him the money and everything and stuff. So the next day, when I went in you ordered to pay my rent on the 4th. He said he refused to take my payment. He had filed eviction. So it was nothing that I can say about that because I feel like, I was looking to move anyway come the fall, ma'am. But because I'm looking for a senior living place. But he the one that refused to take my money. He the one that refused to file the eviction because when the police called him and told him that, when the police came out and told him that I had to be evicted, that's what he did not like and everything and stuff. And, late payment could be paid anytime that you're supposed to pay. They never had a problem with that up until 2025 when a new management came in. And like I said, the only problem I have with this, I plan to move before the fall, ma'am, anyway, into a senior living place. But it have not came through yet and everything and stuff, and I'm still looking for a place. So at the end of the day, I'm choose to go. Only problem I have is having this eviction on my file because I did not refuse to pay my payment. He refused to take my payment. Okay, and all I'm asking today is just a timely frame to be able to move out and go, and that's all I have to say. I don't feel like an eviction should be on my, information because I did not refuse to pay. He refused to take my payment, Your Honor.
If I may ask,
Okay,
who is the?
First of all, let me make clear that in a dispossessory, if I rule that you should be evicted as under the law, I can only give you 7 days.
Oh, yes, ma'am, whatever's needed. Okay, fine.
Okay, because now you all can negotiate something different, but under the law, I can only give you 7 days time before the writ of possession will issue to put you out of the property.
Gotcha.
Okay.
Yes,
so
ma'am.
that's where I'm limited. Also, Ms. Powell, if you'll put up the lease for me or screen share for the lease.
Yes, ma'am, I need to pull it up.
Thank you. Because the terms of the lease will dictate, but a lot of times, Ms. Goburn, people will work with you up to a certain extent. You've been in an extended stay since 2018. That's a long
ma'am. Yes, ma'am. I got an eviction.
So what I'm saying to you is people will work with you, like what's the written document says, sometimes they'll deviate from that. But when it comes to court, I have to look at what the written document says.
Understandable.
Giving me a valuable piece of information, which is that everything was going fine until new management came in. So you sort of had an agreement, whether it was per the terms of the written agreement, but you sort of had an agreement with the previous managers. When the new management comes in, they may change the way they do things and more stringently follow the written lease term.
Okay.
So if you're late a couple of times, they may not be as forgiving as the previous, because they're new people and they're going to do things differently.
Right.
When it comes to reviewing it, I have to look at what the terms of the lease said. So like in that last case that we just went over, the whole problem with that was there was no good contract for me to make a decision on.
Okay, and I understand, ma'am, 100%. But what I'm just
Okay.
asking you is that why should I have an eviction on my file while I wasn't the one who refused not to pay?
Okay.
You know.
I get that, but the other option would have been for you to leave instead of letting them evict you. If you already out, they wouldn't be able to evict you because what they're asking for is the possession of the property and I guess presumably a judgment for the amount owed.
Right, understandable. Okay, well, is there any way I can at least have up to 2 weeks to get pack my stuff and find a place to go?
Okay, so I just told you, I'm limited in what I can give you. Okay, go back, Miss Powell. Go back to slow down. Stop.
In the second full paragraph there, the one that begins a damage deposit of up to, last 2 lines of that contain the deadline to pay at 11:01 a.m. for whatever rental period you're renting, whether it's daily or whether it's weekly.
No, that looks like a damage deposit. Go up just a little bit, Mr. App, right there. So it says guest registration agreement. Minimum occupancy for each 1-bed suite is 3 people. Let's see, no minor children to be left unattended. Room charges, this is where we go. Room charges are due and payable in advance. Rooms are only rented by the week or any longer purchased period of stay agreed to by the parties. I understand that no prepaid room charges will be refunded if I stay less than the purchase period of stay. The registered primary guests and all additional guests are jointly and severally liable for all room charges, and this does not release any guest occupying the room from his or her obligation to pay. Payments for room charges can be made by the additional registered guest, but the return of any deposit can only be received by the registered primary guest. The registered primary guest retains all rights to remove room access privileges for any and all additional guests. So my understanding is it didn't matter there were no additional guests, but it does say that the room payments are to be made in advance. Okay, so come down a little bit further, Miss Powell, pull it down a little bit. Okay, stop right there.
No, this is accurate.
Guest acknowledges and agrees that if payment has not been received in full by 11:01 a.m. on the due date for cleaning, remove any personal property remaining, and the room will be rented to another party at management's convenience.
That's the 11:01 a.m. due date for payments.
And then you normally can pay the late fee, and nobody else ever had a problem with paying the late fee. Even he didn't even have a problem.
Hold on. What is the late fee? Is that the $50?
No, the $50 is the deposit, which Miss Marilyn doesn't have to worry about because she's in a traditional room. Traditional rooms don't require deposits. The late fee for the day is only $5. Miss Marilyn, when she comes to pay, she does pay the late fee, but is late.
Where's the $5 late fee in this contract?
That's only if she's after 1 o'clock. The late fee applies at 1, but she has to pay by 12.
Okay, where's this?
No, it wasn't by 12. Y'all had us paying by 5:30.
Ms. Goldberg, I'm asking questions. Y'all have no clue how this works. I gotta figure out what's going on.
All right.
So what I'm saying to you is I am bound by the lease. Y'all might have worked out a lot of side deals, but when it comes to what I have to determine, I'm
Okay.
bound by this lease. Now let
No
me ask my
problem.
question.
Yes, ma'am.
All right, so ma'am, all right, ma'am, let me ask you the question. Are you on the bed?
I can't hear you, ma'am.
I'm not talking to you.
I can't hear you. Yo, can't yo. It sound like it was breaking
Miss
up.
Brianna,
Yes,
why are you, it looked like you in the bed?
I'm just sitting on my bed. I'm off today.
Okay. So where in the lease does it say there's a $5 late fee?
1 second, I'm looking. Because when Miss Marilyn checked in, she also got a welcome packet.
Okay, I'm not asking you about that.
No, ma'am, I'm looking for you.
Okay, that what I want you to concentrate is on these 3 pages. Tell me where in the lease is there a $5 late fee?
Give me 1 second. I'm going through the papers.
They made it up. May I speak? You on? I'll wait till you get.
No, ma'am. No, ma'am. I'm not asking. No, ma'am.
Okay.
Well, it looks like in the guest agreement, it doesn't state about the $5 late fee, but it's in the system at work. So in the guest agreement, is I don't see it in the guest agreement. The $5 amount.
So, Mr. Richard.
Yes, ma'am.
What did she fail to do? What was the breach of this lease?
When she made payments late, we're not seeking collection of any late fees, even in the additional amounts due.
And when we're talking about when she made payments late, you gave me a list of dates that she made the payments. And so presuming from this lease, those payments were to be made by 11 a.m. on the particular date. Is that correct?
Correct. And
okay. So tell me when she made attempts to pay on those days and how do we know it was late?
If Ms. Powell can scroll to the folio, which is Exhibit B.
Go ahead, Ms. Powell, down at the bottom.
And it should be the second page of the folio.
Mm-hmm.
Right there. If we look at first, January 30th, 2025, we see a late fee just below where the cursor is right now. So January 30th, there's a late fee.
So what's listed as Georgia State Hotel Motel fee is actually a late fee?
No, that's different.
No, hold on. Ms. Lowe, hold on just a second. The question was directed to me. So right there where the cursor is.
Okay.
There is a late fee charge on the 30th because the rent was paid late. If you go down to January 31st.
Okay, so on this, it doesn't indicate what time the rental payment was made.
No, but by definition in their system, it's after 11:01.
Okay, but how do I know that?
Ms. Lowe can testify to that as the guest services rep.
Hold on just a second.
You weren't even there.
All right. Go ahead.
So that was the January 30th late charge. There's another one on January 31st. that you'll see there on the folio. January 31st, another one on February 1st.
Mhm.
And because the office is not open on Sunday, if you're on a daily rate, you have to pay 2 days on a Saturday. Otherwise, you'd be late come Monday. And then the offending late charge on February the 3rd is listed there. Now, as Ms. Dobrin said, she did in fact pay all amounts due on the 3rd, and that's reflected on the 3rd page of that folio. If you scroll a little bit further down,
Okay.
as of February 3rd, her balance was 0. So the
Okay.
breach of the lease was the 4 late payments, January 30th and 31st, February 1st and 3rd.
Okay. I don't know how y'all charging a late fee that's not in the lease, because that's a novation of the lease. I mean, I don't understand why you can charge that. That's like penalizing her both times. You're charging a late fee. She pays the late fee, but
Yes,
then
yes,
now you're Miss Goburn.
yes, I'm sorry.
I work alone. When I need your help, I'll ask for it.
I'm sorry, Your Honor.
Okay. So she paid the late fee, you let her stay, and now that you've decided you want her out, you're penalizing her again for being late, but you already made her pay a late fee.
But the fact that she has paid the late fee, again, we're not seeking to collect any late fees.
No, but you're seeking to base the dispossessory on a breach of the lease, which was for the fact that she was late. The cure for her being late is the $5 payment, not an eviction because she was late. If you had chosen to evict her, then you wouldn't have taken the late fee and let her stay there. But you have 4 times where you said she's late, and then you said pay the $5, and she paid the $5. Then you're making that the basis of the eviction, and that's not possible because you've already let her cure the late part. You've given her the opportunity to cure. You've novated the lease to the point where you say if you're late, pay the $5, you get to stay. She's paid the $5, you let her stay. And now once she caught up to 0, then you decide, well, we're not going to do this anymore, and I'm going to evict her.
Because under the lease, payments are due by 11/01.
I got that, but as I stated, you worked a novation of the lease. You gave her the opportunity to cure. She did that. So now you want to take her $5 for the late times and kick her out. It's one or the other, Mr. Richard. Y'all don't get to. This is the problem I have with these little extended stay places. I know people need them. I know it's a necessary thing because everybody's not in the same economic standing. But what y'all don't get to do is make up the rules as you go along. Either you're going to put it in the lease that there's a late fee, and that if she pays late, she pays the late fee, she gets to stay. Or you're going to put it in the lease that there's no ability to cure, and after the first late, you're going to be dispossessed. But you don't get to take her money saying, I'm going to cure the late, and then dispossess her based on her being late. No, sir. I find in favor of the defendant.
Okay.
All right, thank you. All right, Ms. Gober, free to go.
Okay, so what I need
not Ms. Gober, not that they're not going to try and evict you again, but at this point they didn't do it right. So with that knowledge, go be free.
Okay, but what I'm asking you, Your Honor, now, what do I need to do? I plan to move.
I can't tell you anything to do. I'm not your attorney.
Okay, so right now.
Right now, you're still in your place.
I'm still in my place. Okay.
Yes.
I just
now,
kind
if y'all want to continue to not take her money, she's gonna stay there for free because she's gonna offer it. But you can't tell her she's being evicted for being late, but let her cure the late by charging her this fee. All right, y'all all be good. Thank you.
I don't understand.
Judge, have you also denied the motion to pay costs into the court registry?
Yes.
Your Honor, I have a question.
Yes, ma'am.
My question is, right now at this point, what I need to do, I'm planning to move out by the end of the month. So I just wait
Ma'am,
for
I
them to file
am
an
telling
eviction.
you, I don't get to tell you what you need to do.
Okay,
I get to decide on what is before me, but I don't get to advise them on how to do their job better. I don't get to tell you what to do better.
Okay.
I'm not your lawyer.
They
What
filed
I'm
an
telling
eviction.
you is what they brought to me is insufficient for them to dispossess you.
He's up until you move out.
Okay,
because
okay,
you
I
don't
got
need that
you.
eviction on your thing.
Okay, all right, ma'am. Okay, I can just pay them daily fee until I'm get ready to move out, and then I can
Just don't be late. That's all I say.
thank you. Start
That
on
late
tomorrow.
fee is not in the lease.
All right, thank you.
All right, thank you. All right, everybody, bye.
Judge, do you have a second to hang back?
Okay, hold on. Let me